Hello guys, welcome back to another video of business law subject, and this is chapter 5. I'm going to cover this video, and the chapter 5 is known as law of agency. So let's get into it. So introduction to the law of agency. So what is a law of agency? It says that in Sri Lanka. So, according to the legal dictionary, agency means a consensual relationship created by contract or by law, which where one party grants authority to another party to act on behalf of or under the control of principal to deal with the third party. So that's what an agency means. So agents such as travel agencies, work agencies, construction agencies, so these things are an agency. So these are like a second party, to deal. So you pay them, you will be under their contract, and then they deal with the third party. So the principle is, so the agent's relationship is a person who gives authority to another called an agent to act on his behalf, on her behalf. So what is an agent? Agent is a person who is authorized to act on behalf of a principal. So you know what is an agent or a consultant. The applicable law is the section 3 of the civil ordinance. So the civil act, civil ordinance number 5 of 1852 is known as CLO. So this is actually agency law. It's actually derived from the English law, as the governing agency Sri Lanka is based pretty much on English law, so known as common law. So there'll be like a lot of English cases that you won't be reading. And so it's going. So capacity to contract of the party. So general rule, it is the compulsory for the principal to have full contractual capacity in order to enter into a contract of agency. But since the agent does not contract for himself, he need not have full contractual capacity. Even a minor or a bankrupt person can function as an agent and bring about a binding contract. So principal to a third party. So yeah, the creation of an agency. It says in order to an agency, in order to be created, you should have express agreement, implication or conduct by law, and by necessity, ratification, estoppel, marriage, and cohabitation. Yes. So creation of an agency by express agreement. So majority of the agents relationship are created through an agreement between the principal and the agent. So according to the Sri Lankan by the power of attorney ordinance number 4 of 1902 says the written appointment need not to take any particular form unless the agent is authorized to make a contract under seal. In such situation, written appointment is called as a power of attorney. So normally power of attorney, as you know, in simple terms, that a land power of attorney or property power of attorney is that you allocate the power of the property except selling. Either you can mention they can sell or not, but they will be legally liable for that particular property. So they can either rent it out, they can lease it out, they can do whatever they want, but they have to maintain it, they have to look after the property, but they don't have the right to sell it. It depends on the owner. Some power of attorneys, they have given right to sell, right to rent, but some power of attorneys, they just given right to rent only and for maintenance. So this is a classic example. regarding what I have said. So creation of agency by implication or conduct. So in the creation of agents in the manner, no evidence that an agent has been appointed by the express agreement, but from the circumstances of the situation, it can be seen that agency is created by the implied conduct of the parties. And there's a case, agency 20th edition 2014. It says that an agency agreement between the principal agent will be implied where one party has conducted himself towards another in such a way that it is reasonable for that other inter from that conduct assent to an agency relationship. And there's a case, agency by implication. Haley Hutchinson, owned by a company called Purdue Electronics. Another company called Brayhead Limited, acquired by PEL. Richards was the chairman of the board of directors of BL, but he was not appointed as the managing director of BL by its board. So the reason, so so it was held that board of directors BL, by allowing Richards to act as its managing director over a period of time in relation to dealings with HH, had impliedly authorized him to enter into this contract. Therefore, BL was liable to pay HH on this indemnity contract. Yeah, so quite an interesting case. So, by creation agency by operation of laws, either. So these are the following ways: necessity, ratification, estoppel, marriage, and cohabitation. So these are the how they have done it, by necessity. So let's go. So agency by necessity. So agency of necessity occurs when a person is entrusted with another property and becomes necessary to do something to preserve that property, although there is no express necessary to preserve that property, although there is no express authority to do the act necessary to preserve that property. Authority is presumed due to the necessity. So there's a classic example. So X met with an accident, was taken to the hospital in unconscious. Doctors want to operate on him in order to save his life. Under normal circumstances, X would have give his consent for this operation to perform on him, but in this instance, such is not possible. X's wife Y can decide on behalf of X. Here's Y is acting as an agent of necessity. Yeah, so there's a condition must be satisfied before the necessity should be impossible to get through principal instruction. There must be and an actual and definite commercial necessity for creation of an agency. The agency must act in good faith for all the parties. And so this is the Great Northern Railway versus Swarfield. This is actually quite a highlightable case when it's come to in English law. Please read that and read these cases. So in order to get your idea. And so the commercial necessity. So this is the case according to commercial agency by ratification. When the agent has no authority to contract on behalf of the principal or exceed his authority, the contract will not be binding on the principal. But the principal can later on confirm and adopt this contract and make this contract binding on him. This is called ratification. Okay, so let's go for the example. So without excess knowledge, Y purchases a car, saying that he is purchasing the car on behalf of X. Subsequently, if X approves this transaction, then this approval is known as ratification. This results in Y become an agent of X and X being bound by the contract to purchase this car. Yeah, so in ratifications that someone is doing, an agent is doing, either in a business environment, CEO or chairman has a PA, personal assistant. They are the one who does all the conducting of interviews, clients, meetings, and etc. and etc. With the other company's behalf of the boss, the CEO, the chairman, because he or she might doesn't have time, so he gives the authority to PA to do this. So the PA is the agent of him. So that's how it is. So so this contract with the conditions and the cases. Brook versus Hook. So agency by estoppel. Estoppel means when a person allows a third party to believe that they are that there's a certain state of affairs exists. He is prevented from denying the state of affairs at a later time. If the third party has acted to the third party on detriment by relying on that state of affairs, therefore, in the law of agency, when a person represents to the outside world that someone is his agent and a third party deals with this agent as an agent, then the principal is prevented in denying this agency. This type of agency known as estoppel agency. Further, this agency is created by implication. Yes, so estoppel. So you give the contract to someone to do it, later they have done it, and later they are pretty much denying it that they have not involved, so that's how it is. It's by estoppel. So sometimes you have to be careful of what sort of agency that you are dealing with. And there's a so let's go for the example. So A is for the last few months had allowed B to buy goods from Z on credit, and A has subsequently settled Z's for these purchases. Thereby, Z was made to believe that B was A's agent. Now, A cannot refuse to pay Z on purchases so made by B on the grounds that is B is not his agent. In this incident is one of where by the implied conduct of the parties an agency has been created by estoppel. So yes, it's quite simple, straightforward, and here is a case regarding that. Let's read it. Bobby versus Taylor. The Taylor, the defendant, read the room in his premises to B, who was also conducting similar kind of businesses. B got his business leaflet printed by plaintiff Bobby, which is fact was informed by T by B. The invoice for this printing work sent to P to T, which were not challenged by T, and these were anyway paid by B. But as some of these invoices not paid by P, sued T for payment on them. It was held that reasonable for plaintiff to interfere that B was ordering the work with the defendants his authority, therefore T was stopped from denying the authority. As an agency had been created by estoppel, as a result, T was liable to pay for these outstanding invoices. So next time when you conduct an agency, be careful. Sometimes things might turn against you. Agency by marriage and cohabitation. So the common law accept during times when most wives stayed at home and did not earn their own living. Therefore, when the husband and wife are living together, the wife is presumed to have her husband's authority to purchase necessaries on his credit. So necessaries are items such as food, clothing, education, medical needs, such like which are essential for the spouse and the children in keeping their social standing. So this is this agency by marriage and cohabitation is also pretty much part of family law as well. So if the husband failed to provide these dues or with for the wife and the children, the wife can go to courts and ask a huge sum of compensation by applying this law. So um, yes, how it is. So Let's read this case. Uh, Also, Pianta versus Macro and Sons. Husband was a miner who earned £10 per fortnight. His wife purchased a diamond ring worth of £11 and 15 shillings, which was more than husband's fortnightly earnings. She bought this ring, pledging her husband's credit. The issue to be determined was whether an agency of necessity has been created in this instance. So it was held that diamond ring was not a necessary article but an item of luxury for the lifestyle of a miner. Hence, an agency of cohabitation has not been created. As a result, the wife had no authority to bind her husband as a principal to the trader who sold her diamond ring on credit. Therefore, the trader cannot claim its cost from the husband. Under the following situation, the presumption that the wife has her husband authority to purchase necessaries on his credit can be rebutted by the husband by proving that he expressly forbade his wife to purchase on his credit, or he expressly warned the supplier not to supply on credit to his wife. His wife has already been sufficiently supplied with the goods for the kinds of in question. His wife has sufficient means, allowance to purchase without pledging the husband's credit. The order made by his wife was excessive or extravagant. So, quite an interesting case. And please do a research regarding this, because these the kinds of things will come for exams. So, types of agents: auctioneers, estate, mercantile, factors, commission agents, brokers, confirming houses, del credere agents, and these are the who are the auction mercantile agents, commission agents, who are the brokers, confirming houses, del credere agents. Yeah, keep going. So let's read deal credit agents. This is type of special agent who has a guarantee as for an extra commission. He gives an undertaking that purchase with whom he enters into contract on behalf of the principal will pay for the goods they take. In the event they do not pay, he will pay for on their behalf. Yeah, so it's like an insurance. So the authority, so they have the actual authority, express, implied, apparent, or ostensible authority. So these are recognized under law. So these mainly they argued with common law, with the case law in regarding this, and these are under pretty much in the civil law, not in the criminal law in sense. And keep going. So the what's the type of authorities and the cases regarding for customary authorities. There's Bailey versus Bailey Company Limited. And this is called ANZ Bank for business usage. So sustainable authority. So let's read this. Here the agent has not been given any real authority, whether the express or implied, to do certain things, but the manner in which the agent acts gives the appearance or impression that he has the authority to do so. In other words, principle of an agent by conduct make the third party feels that the agent is ostensible or apparent authority. Hence, this type of authority is known as apparent and ostensible authority. Um, let's read the example. So, X went to a restaurant to have a cup of tea. The waiter tells him that if he orders a burger, he will get a cup of tea free of charge. So, it is reasonable in his instance for X to think that W is acting on behalf of the restaurant owner as his agent. As a result, W will have the apparent authority to make this offer to X. Yes. So that's how it is. And it's case laws. Please read these case laws. These are actually quite important, and these things will obviously come for the exams to at least from one topic. There will be a case law and a definition. So Rights and duties of an agent. Uh, to exercise due diligence in the performance, his duty to apply any special skills, to disclose the principle as any account for the knowledge, and to exercise within the standard of care. So this case called Heath versus Parkinson. Heath was appointed as an agent by Parkinson to find a purchaser for P's leasehold premises for £2,500. H knew that the large tailoring firms willing to pay this price, but P was under impression that landlord would not consent the premises for being tailoring business. As several tailors were anxious about to buy P's leasehold rights, H, without informing P, obtained the landlord's assurance that they would consent to a tailoring business being carried down their premises. H concealed from P the fact the landlord has so consented. It further concealed that P is prospective buyer from the lease. He was indeed by tailoring firm, and so induced P to sell his leasehold right on the premises for lower figure as 2,250 pounds. So held that agent H should have disclosed to the principal P anything to come into his knowledge which is likely to influence P in the making of the contract. In this instance, H had failed in carrying out his duty. Yeah, so that's how it is. And exercising a standard reasonable care, and Chowdhury versus Prabhakar, all England. It's a British case. The case laws regarding best interest of the principals, and we got secret profits. Boucher versus ALT. Secret profit again. Hippisley versus Nee Brothers. So, if the agent does not make a secret profit without principal's consent, the principal has right to do any of the following: refuse to pay the agent, repudiate the contract, recover the secret profit, dismiss the agent without any notice. We will keep moving on. So, note the delegates of agency authority. So, principal ratifies delegation. So, yeah, it comes for rights and duties of principal. So, the main duties towards his agent means us, right towards us. So if we take an agent's work, agents, so what sort of rights and duties should follow from our behalf? So it means pay the agent his commissions or the remuneration, to indemnify, it means compensate within the lawful acts done by them and the liabilities by execution of his authority. And so to indemnify the agent, there was this case that Christopher Rides was involved in speculative dealings on the Liverpool and the New York cotton markets. She appointed a broker to make these speculative purchases to cotton on his behalf. Subsequently, she became heavily indebted to the broker due to fall in the price of cotton in the market. Thereafter, the broker, as he was entitled to do so, closed the account and sold the cotton which he had purchased in behalf of C at a loss. So, as the broker was personally liable for on this contract, the sale of cotton resulted in the loss to the broker. Held, the broker was entitled to be indemnified by C for the losses sustained by the broker. So yes, so obviously that means if you has taken someone's work from someone, you have to pay. Simple and easy law, which has been applied. Termination by agency. The agent principle is not an everlasting one. It is to has time frame. The methods available to terminate is this agent principal relationship will be explained in this section. An agency could be terminated by either an act of the party, an operation of the law. By an act of the party, which means by mutual agreement by when the agent has complete their performance contrary to the agency, the principal revoking the agent's authority, dismissal of the agent upon breach of duty. So, by operation of the law, says that by the death, bankruptcy, or mental incapacity. And so it's called illegal contracts. There are some certain cases, and as an example, frustration. So according to the frustration, also it can. So it says that an agent is asked to sell a house. An unexpected fire destroyed this house completely. The agency stands terminated, and it has become impossible to perform the contract anymore due to frustration. Frustration is a doctrine in the law of contracts where a contract is set aside due to an unforeseen event which makes it impossible for the performance of the contract, or radically changes the party's main purpose of entering into the contract. Yes. So if something's if you tell for a contractor, that means an agent, to sell something or to get something, but at the end of the day it has been damaged or been destroyed, you don't have to pay, since they have not sell their duty because of the damage. So you don't have to. You can file a case regarding frustration and to avoid paying for your agent. Uh, so the liability of an agent for contract. So an agent really acts as a bridge, forming contracts between principal and the third parties. So generally, agent is not held liable under these contracts, but in exceptional situations, they will be held liable. So what are the things that the agent is held liable? In exceptional cases, which are when the agent is contract for named principal. So says that as the agent only acts as a conduit in bringing about the contract between the principal and the third party. Generally, the agent is not held personally liable on such contract. So the third party in the time of contract, contracting as an agent for name of principal, legal liability in relation to contract falls upon principal and the third party. So when an agent is personally liable on the contract, says when the agent does not indicate to the third party that he is contracting as an agent, and when the agent is contracting on behalf of an unexisting principal. So there are cases, agent contracts on behalf of non-existing principal. Kellner versus Baxter. It says that it was held that promoters are liable on the contract personally as proposed company, which is the principal, was not in existence at the time of agent enter into the contract. So these are the things for in order that agent, in order to justify their non-existing principles. And so 7.2, when the agent contracts for an unnamed principal. So this situation arises when an agent discloses that there's a principal but does not name the principal. Okay, so the case law versus Tehran Europe Company versus ST Belton Tractors. So in this case, it was held that T, which is the defendant, is unnamed principal, so therefore T could sue B directly rather than suing R. Okay, so the next one is when the agent contracts for an undisclosed principal. So it can be into two scenarios, whether it may be possible for the undisclosed principal to subsequently reveal himself as a principal and enforce the contract with the third party. This rule is called the doctrine of undisclosed principal. So second one, the third party, after discovering the principal, has the option of electing a whole liable and sue either the principal of an agent. Once the third party chooses his option, he cannot change it later and sue the other. Case law for liability of an undisclosed principal. Wattiu versus Fenwick. Wattiu supplied of cigars on behalf of Victoria, located in the Middlesbrough. The beer house was operated by Humbo, which means the H. And so, because W supplies cigars to H, in which W was not paid for. Then W sued F. So who is F? It was held that F and F had held H out to the world as general authority to act on behalf of F. As a result, it was established that F was a principal. Therefore, the ordinary rules of principal and an agent apply in this instance. Notwithstanding the fact that the agency relationship was unknown to W, therefore, as a principal is liable for acts of his agent, F was liable to pay W for the unpaid cigars. And it's come for the liability of the state for acts of an agent. So how does the state come in regarding for liability of its agents? So uh, if it's a delicate or tort, is a civil wrong which is results in inflicting loss or harm to the affected party due to an intentional or negligent breach and duty by wrongdoer, which gives affected party of the right seeking damages from the wrongdoer. So the State Liability Intelligent Act number 22 of 1969 deals with the delictual liability of the state of acts as an agent as per the section 2 of the act stated. They can held liable if it's a private fully contractual capacity for delicit delicts committed by its agent. Acts of an agent which state is held liable according to section 2 and section 3, it has been mentioned. Acts of an agent of a state is not held liable. Also said that by an omission, judicial or quasi-judicial nature depends on the judicial process that is happening, and it keeps going until to section 5 and 6. And yes, so that's it. That is the end of chapter 5, law of agency, I guess. Okay, check. Yeah, so that is the end of chapter 5. So thanks for you know having this, and I will see you on the next chapter.